Welcome back to the Deep Dive. Today, we're immersing ourselves in a really critical piece of South African legislation. It's the reform of Customary Law of Succession and Regulation of Related Matters Act, Act 11 of 2009. Quite a mouthful. Our mission today is pretty straightforward. We want to guide you through this, well, sometimes complex legal structure. We're aiming to go beyond just reading out sections. We want to give you the key insights, the purpose, the mechanics, and importantly, the real-world significance of this act, because it fundamentally reshaped inheritance for millions living under customary law.
Absolutely. And it's not just history. This act is very much a dynamic legal cornerstone. It was passed in 2009, started in 2010, but its relevance is ongoing. In fact, just recently, October 2024, its administration, the powers and functions were formally transferred to the Minister of Justice and Constitutional Development. So it's firmly anchored right there in the justice system.
Okay, right. Let's unpack this then. Before we get into the how it works, we really need to understand the why. What was the fundamental legal crisis, the constitutional pressure point that basically forced Parliament to step in and change these long-standing customary succession traditions?
Well, the heart of the problem was really a clash between fundamental human rights and tradition. If you look at the Act's preamble, it lays it out clearly. The traditional customary law of succession, specifically that principle of male primogeniture, it was simply deemed unconstitutional.
And for listeners maybe not familiar with that term, male primogeniture essentially means inheritance passed exclusively down the male line, usually to the eldest son, right? Effectively excluding wives and many children, especially daughters, if the head of the family died without a will.
Precisely. The preamble specifically mentions that widows in customary marriages, and certain children too, just didn't have adequate protection and benefit under that old system. And that flew directly in the face of Section 9 of the Constitution, the right to equal protection and benefit of the law for everyone. You see, the Constitutional Court had already made a definitive ruling. They said this system, this male primogeniture, just couldn't be squared with modern ideas of equality and human dignity, which are, enshrined in our Bill of Rights.
Yeah.
So this is where it gets really interesting. The Act is Parliament's very deliberate, detailed answer to that court order. It wasn't really a choice. It was a legal must-do.
Okay, so Parliament gets this challenge. Scrap the old core mechanism male rule, but figure out a way to still respect and protect unique customary family setups.
Yeah.
How do they actually manage that? What's the core legislative fix that tries to achieve both constitutional equality and, well, practical application?
The core solution is laid out in Section 2, which is titled Modification of Customary Law of Succession. And the, I suppose, genius of it lies in its approach. Parliament decided to effectively import the mechanism used in civil law. So, rule number 1. If someone subject to customary law dies without a valid will, dies intestate, their estate must now be dealt with under the rules of the Intestate Succession Act, 1987. We usually just call it the ISA. That alone is a huge shift, overturning potentially centuries of social practice right there.
But wait a minute, just importing the ISA wholesale, doesn't that risk kind of erasing customary succession law altogether? Is that really harmonization, or is it more like forcing customary ways into a civil law box?
That's a really important point. And the Act tries to achieve that harmony by using the ISA as a sort of neutral standard tool to get that constitutional equality. But, and this is crucial, it modifies the ISA to recognize the actual social realities of customary unions. It basically says, okay, we'll use the civil law framework to divide the assets fairly, but we'll let customary law help define who actually counts as family for that division. Before this act, the ISA actually had clauses excluding customary law estates, often pointing back to really outdated laws like the Black Administration Act. This 2009 act simultaneously amended the ISA itself, deleting those old exclusions. That really sealed the integration, making sure all intestate estates, whether the person lived under customary or civil law, now fall under one single constitutionally sound framework.
Okay, that clarifies the approach much better. Now, talking about those modifications, what are the key adjustments made to the ISA to make it fit with customary family life?
Right. The first really critical adjustment concerns the surviving spouse. If the deceased leaves behind a spouse and a descendant, that surviving spouse now inherits what's called a child's portion of the estate, or they get a fixed monetary amount set by the Minister of Justice, whichever amount is bigger. It's designed to make sure the primary partner has some financial security. And Section 1 defines spouse clearly to include a partner in a customary marriage that's recognized under the Recognition of Customary Marriages Act of 1998. So it's tied into that framework too.
Okay. Now, I imagine the really tricky part comes in where customary families get more complex, maybe involving children or unions that aren't typical under civil law definitions. This must be where the Act needs some serious nuance. How did Parliament manage to expand the idea of a descendant to ensure fairness in those situations?
This is, I think, truly one of the most powerful aspects of the Act. They absolutely had to recognize people who were considered family under custom, even if they didn't fit the strict biological or standard legal definition of a descendant under the ISA. So the Act expands descendant to bring in two significant groups. First, it includes any person who, during the deceased's lifetime, was accepted by the deceased as their own child, according to customary law. This really acknowledges that social acceptance, that lived reality, can be just as important as biological ties for inheritance.
That makes sense, recognizing the reality on the ground. But what about those very specific customary unions, the ones maybe created more for lineage purposes than partnership? I'm thinking of cases where maybe a woman entered a union specifically to bear children for the house of one of the deceased's existing spouses. How are they handled?
Yes, that's a fascinating aspect. The Act makes sure these vital family roles get financial recognition. It directly addresses those unions created, as you say, perhaps purely for procreation or continuing a lineage, rather than being a typical marriage partnership. The Act specifically states that a woman who entered such a union with the deceased to provide children for the house of a surviving spouse must, if she survives the deceased, be regarded as a descendant herself for the purpose of inheriting under the IS. So the law is essentially translating a specific customary social function, providing lineage directly into an inheritance status, the status of a descendant, within this modern civil framework.
Wow. Okay, that sounds incredibly complex to actually administer, though, especially when you're calculating how the estate gets divided up. If you've broadened the definition of who counts as a descendant, how does that change the maths, figuring out that child's portion?
Yes, the Act specifically addresses the calculation. It mandates an amendment to how you figure out the divisor to reflect this bigger family unit. When you're working out the child's portion, you can't just divide the estate value by the number of biological children anymore. The divisor now has to be calculated by adding together a few things: the number of children and other descendants, like those accepted under custom, plus the number of surviving spouses, plus the number of these specific women we just talked about, the ones regarded as descendants because of their customary role.
Could you maybe give us a quick, simple example just to make that concrete?
Sure, let's try. Imagine an estate is worth, say, R1 million. If the deceased is survived by 4 recognized descendants, maybe 2 recognized spouses, and one of these designated women whose union provided children for one of the houses, then the total divisor becomes 7. That's 4 descendants plus 2 spouses plus 1 designated woman. So you divide the R1 million estate by 7. Each surviving spouse and that designated woman would receive that resulting portion, or the minimum fixed amount set by the minister, whichever is larger. And importantly, the Act builds in protection even if the estate is quite small. If there isn't enough money in the estate to give each surviving spouse and each designated woman that minimum fixed amount, then the estate must simply be divided equally between all those surviving spouses and designated women. It ensures a baseline protection for those potentially most vulnerable, no matter the estate's total value.
That focus on equitable distribution, that clarity, seems absolutely central. Now, property is one thing, but the Act also touches on testamentary capacity, the right to make a will. This seems to give women control over property maybe allotted to them under custom.
Exactly, that's Section 4. It makes it explicit that any property that was allotted to a woman or accrued to her house because of her customary marriage can now be disposed of by her through her own will. It grants her that final individual testamentary control over that specific family property. And what's more, if she does make a will, any mention in it of her child must be read to include children born from those specific customary unions designed to provide children for her house. So again, the law is trying to ensure her wishes, as expressed in her will, align with the actual customary family structure she was part of.
Okay, let's shift to the practical side of things. With such a massive legal change, disputes are almost inevitable, aren't they? What happens if there's uncertainty about someone's status or what assets are involved or how family property should devolve now?
Section 5 tackles this head-on. It sets up the mechanism for resolving these conflicts. If there is uncertainty, the master of the High Court, who has jurisdiction, steps in. The master is given the power to make a determination that is just and equitable to sort out the dispute. And crucially, the Act says that before making that final decision, the master may direct an inquiry to be held. And that inquiry can be conducted by a magistrate or, significantly, by a traditional leader from the relevant area.
Ah, so the system acknowledges the need for local knowledge, local context. The master, who operates within the constitutional framework, can rely on traditional authorities for facts and understanding about the specific customary situation. But the final legally binding decision still rests with the formal justice system, with the master.
Precisely. And there's a guiding principle for everyone involved, whether it's the master, the magistrate, or the traditional leader conducting the inquiry. They all must have due regard for the best interests of the deceased's family members and the equality of spouses in customary and civil marriages. That phrase acts like a constitutional backstop, underpinning the whole dispute resolution process.
Pulling all this together, achieving this kind of harmonization must have required a huge legal cleanup job across different existing laws. We touched on the ISA amendment already, but what other sort of historical fixes did this act put in place?
Right. Well, the Administration of Estates Act from 1965 was amended. This was to make sure the master of the High Court's jurisdiction now clearly covers all those estates that were previously handled purely under customary law principles. It basically standardized the whole admin process. But maybe one of the most poignant historical corrections was the change made to the Maintenance of Surviving Spouses Act of 1990. This change addressed a very specific historical anomaly, an exclusion that could cause real hardship.
Oh, which exclusion was that?
This amendment brought protection to women whose customary marriages had effectively been dissolved because their husband later entered into a civil marriage with someone else. Specifically, it targeted situations that happened during a particular historical window between 1929 and 1988. Before this reform, these women could find themselves unable to claim maintenance from the estate simply due to the timing and the legal technicalities of the husband's subsequent civil marriage. The 2009 Act made absolutely sure they were explicitly included as survivors who could claim maintenance. It was a really crucial final step to close that historical loophole and bring justice to a group of women who had been marginalized.
You know, this whole deep dive really highlights just how sophisticated this legislative effort was.
Yeah.
It seems to use a standard civil framework, the ISA, to achieve that baseline equality demanded by the Constitution. But then it makes these really intricate, almost surgical modifications to ensure that unique, sometimes complex, customary family relationships like that expanded definition of descendant are fully recognized and protected within the law.
It's a remarkable balancing act, truly. However, it does raise an interesting question looking forward. The Act is very clear in Section 6 that it does not change any customary law rules about disposing of property held by a traditional leader in their official capacity of property held on behalf of a traditional community. So if we think about the bigger picture of legal reform, how will this modernized succession law dealing with individual family property continue to interact with and maybe evolve alongside the customary law that still governs official communal property? That tension, between individual constitutional rights applied to family inheritance and the collective structure of traditional community leadership and property, that remains a really dynamic area of law to watch.
A really fascinating tension, absolutely. Something to keep an eye on as the law continues to adapt. Thank you so much for walking us through the constitutional reasons and the very intricate details of the Reform of Customary Law of Succession and Regulation of Related Matters Act, 2009. We really encourage you, our listeners, to maybe explore the full text of the Act if you're interested, just to see the depth of this legal harmonization effort for yourselves.